Thank you so
Thank you
much.
so much, Justus. That's been really, really interesting. So we have a lot of delay. Clearly, we are 30 minutes uh, past the time I expected to start the Q&A, but I think it was worth it. So even though, some people have left, I suggest that we can start the Q&A anyway. The transcript will be created and the recording will be made available. So we received many questions. So that's worth trying to at least start with some. Will you agree, Justus, to continue a little bit?
Sure, absolutely.
Okay. So the first one is some believe that the European Union will benefit from such a regulation as the EU is a region of implementers. Will you agree with this statement?
I think that I would disagree both in specifics and on a more general level. I would disagree in specifics because I think that it's based on a pure arithmetic where you say, okay, do we currently pay more than we receive from SEP licenses? And I think that this is heavily biased or heavily skewed by the fact that the largest recipient of royalty payments in the world is a US company. But I believe that this US company, Qualcomm, is not going to be significantly affected by this proposal because they do not rely on litigation in the EU to enforce their royalty rates. So if you take this one licensor out, the remaining licensors that will be heavily affected by the proposal in this group, this group is very heavily dominated by EU companies. So if you only focus on those licensors that rely on enforcing their SCPs in European courts, then I believe that European interests are clearly overrepresented on the licensor side. So this is a specific point where I would say that the proposal actually shoots the European companies that are currently at the table in the foot. And I think the broader and more important point is that we should not make this kind of industrial policy arithmetic at all. We should look at what is good for our future, what is good for the technologies that are to be developed 20, 30, 40 years from now, and starting to develop an industrial policy strategy that is more typical of developing countries, where we basically say we try to free ride on other regions' innovations. This cannot be a model for Europe that we want to follow. I think we want to encourage innovation in Europe. We want to be a region that innovates. We want to be a region that not only proposes new regulations, but that also develops new technologies. And therefore, we cannot make policy based on the belief that we as Europeans will no longer be significant on the side of innovation.
Very clear. Then on slide number 7, you mentioned that the reasonable aggregate royalties idea is actually based on the expert group report proposals 42 and 44. But you were also a member of this expert group too. Was this proposal unanimously supported by the expert group?
No, none of the proposals were, and I mean they were not intended to be. It's important to recollect that all these proposals were proposals made by individual experts. They were discussed in the group. They were all then collected in a list of proposals. I think we had a system of voting on these proposals where like these different parts of proposal 42 to 43 to 44 were received very differently. And I think that this makes a lot of sense. So the initial idea to encourage SEP licensors to make statements, offer reassurance to the other side what the maximum rates are that they would be charged. There's nothing wrong with that. That's already legal, and companies can elect to do that if they wish, and if they do so, that has the potential to be useful. But then as we move forward in the proposal, and especially when it comes to the intervention of an expert panel that would basically take this decision out of companies' hand and say, okay, since you are not capable of coming up with a rate now, I will do that for you. This proposal has not been very favorably received. I believe it's one of the less favorably received proposals out of the almost 80 proposals in the report.
Okay, so despite this very minor support, he went through the regulation. That's interesting. Um, the following question is, you touch upon geopolitics on slide 18. Will you be able to tell us more about this? Do you fear something? Do you believe that will be good? How you will characterize this part?
Well, I fear two things in a way. I mean, I fear obviously the short-term pain that undermining European efforts to protect EU companies' rights internationally would, in particular in the WTO with China. I mean, it's very difficult to square the position that on the one hand we're upset with other world regions being insufficiently protective of European companies' patent rights, and at the same time having a proposal of an administrative process intervening in the formation of prices for licenses. So I think that this will be the most immediate effect of the proposal, is to basically undermine this effort. And the other thing, which I think is much more significant, I'm much more concerned about, is that we are already at a perilous stage in the standardization ecosystem. We still have a global standardization ecosystem to some extent, and we have a global SEP licensing ecosystem, but I think it's very clear that this is increasingly fragile. And now coming out from Europe with very assertive regulatory proposals. Okay, forget everything that is being done right now. From now on, we're going to do it this way. This is going to clearly drive a wedge between Europe and the rest of the world. And I think we as Europe have most to lose if this global standardization ecosystem disintegrates. I think we are way overrepresented in the international standardization ecosystem compared to our weight economically or technologically. I think it has served Europe extremely well, this international standardization ecosystem. So anything that would lead to international fragmentation is absolutely against European interests. And I believe that this current proposal, as it is drafted right now, has the potential to increase fragmentation.
Okay. Next question is on slide 19. You refer to a chilling effect on ongoing licensing negotiations. Will you be able to further explain why?
Yeah, I think there are two ideas also. I mean, one is to say, okay, let's just wait. You know, like we are in the process of negotiation, and then negotiations take on average 3 to 4 years. And so you say, okay, maybe this regulation will become law before our negotiations conclude. And maybe I can take some benefit out of that, and maybe it will improve my bargaining position in this negotiation. So why don't I drag this out a little bit longer to see whether I can achieve a more favorable outcome at a later point in time. So I think that right now, current licensing negotiations are just being impacted. And the other is that there is this notion that the regulation says that these pronouncements should be made for future standards, but it's not very clear what that means, future standards. So if that really means standards for which no patented technology already exists, then of course this regulation would only become meaningful in decades from now. And I don't think that it's a good idea to regulate the far distant future if we're already having difficulty to foresee what the needs of this technology will be. So I think that it's much more plausible to expect that some of the patented technologies that already exist will be impacted and will be covered by this regulation proposal. And then it's a question, okay, if we sign a license today and then other licenses, and then an aggregate royalty statement comes out and that calls for much lower rates, and so other licensees will be offered much lower rates, and probably that means that I need to renegotiate the rates with the licensees I currently have. And so there's significant uncertainty with respect to our existing licenses. So it's just infusing a whole lot of confusion and uncertainty in negotiations around 5G in different industries, which and that's kind of the sad part of it. I mean, they were progressing quite well in the absence of this proposal. So it seems a bit uncalled for.
Okay, very good. And then on slide 19, so you highlighted SEP licensing disputes have decreased, and the figures provided are from the European Commission Impact Assessment Study, that you are one of the authors as well. So why does the European Commission still says that there are many SEP disputes in Europe if the figures are showing that it is not the case?
I can't really speak for them. I don't know what specifically these beliefs are based upon. I maybe one interpretation is that SEP licensing disputes have relatively recently begun to impact industries that had not traditionally been impacted. So maybe these industries have been more vocal or more successful in getting the commission's attention, and so that the commission's perception is that it has increased because industries that the commission cares more about have recently been more impacted than in the past. So this is one possible interpretation, but I think it's just a descriptive fact that the number of disputes overall in the world has not increased. It's there's a clear shift in where these disputes take place, where there is a decrease in the number of disputes in the US, there's an increase in China over time. But Europe is stable, and so is a global number of disputes. And if you compare that with an increasing number of licenses and an increasing number of SEP portfolios, then I would say any kind of reasonable assessment of the share of disputes or the relative number of disputes is on a decline. And I believe that this is difficult to argue with.
Okay. So the European Union has challenged China at the WTO to defend its high-tech sector, especially European SEPs enforcement. How is it compatible with this proposed regulation?
It's difficult to square with the proposed regulation. I mean, when I'm saying with this proposed regulation, I'm also always referring to this particular proposal, because I believe that this particular proposal is particularly intrusive in the determination of rent rates, whereas I don't see similar problems with the proposal to create a register or with the proposal to have a non-binding conciliation process. I believe these are perhaps easier to reconcile with some of these principles. But I believe that the proposal to have a friend determination from an expert panel appointed by an administrative body of the European Union, and then with the underlying belief that this expert opinion would carry weight in court proceedings in the dispute between parties. I think that this any foreign party would legitimately view this as very problematic. So I think that if China had done something like that, I think the EU would have protested against this. So I think that it's difficult to reconcile with the EU's efforts within the WTO.
Okay, thank you. Next one, and we will take 4 more questions. Will you be able to mention the types of companies benefiting from such a proposed regulation? Do you have any idea?
I mean, it's clear that it's given that the definition is clear that we are talking about maximum aggregate royalty rates, it can only be the implementer side that benefits, because there's absolutely no obligation on the licensee side to actually pay these aggregate royalty rates. So if that was not the case, then we would have to discuss this proposal in a different way. But given that it's a maximum rate with absolutely no obligation on the other side, we only have companies on the licensee side benefiting. And which companies benefit particularly? I believe that it's clear that it's not the companies that only take very few licenses, because they are very far away from hitting the aggregate royalty. And then it's also not the companies that have very high profit margins, because these are the companies for which the aggregate royalty is of least concern. So the companies that are most likely to benefit are probably those that have large volumes and low profit margins. So I think that, yeah, high volume discount devices uh, would probably be the ones that pay the highest rates in total in aggregate, and these companies would then also have more to gain from a cap on the aggregate rates.
Okay. Next one is why, in your opinion, this proposed regulation will not help European SMEs, and what would actually help SMEs?
So all the mechanisms in this proposal only really come into play once there is litigation in EU courts. And I haven't seen much evidence of litigation in EU courts against SMEs. I just believe that there's very little assertion of SEPs against SMEs in EU courts, but also in courts more generally. And so this is the first comment. And then the other comment is I think that SMEs might benefit from more clarity, from more pedagogy in a way, and basically from really predictive and objective information. And this is something that could be provided and that could be produced, but I just don't believe that calling upon stakeholders to populate a database with their obviously partisan views of what the royalties rate should be, that this will be useful to companies that are new to this, or that need some kind of first insights, because these companies will view this and they will say, oh, well, there's so much disagreement here and there's so high rates, and then there's it's all over the place. And I think it's more of a distraction than anything else. So I think that if one wanted to provide this kind of information to companies that really have limited previous experience, one would be better advised to just collect case law, collect all the evidence that is available from the public domain about licenses and licensing rates, and make this available in a significant and standardized way. And that would maybe attenuate some of these concerns that SMEs might have, because SMEs might learn that it has been in the past been profitable for most standard implementers to implement these standards, so they should not be discouraged from implementing the newest generation of standardized technology. Unfortunately, what I think is going on to some extent is that some of companies that are not SMEs, but that have an interest in bringing rates down, they create a narrative that SMEs are at risk of paying exorbitant rates, and this narrative is chilling investments by SMEs much more than the actual rates are chilling investments. So I think something that could help SMEs is just objective, descriptive evidence about the truth, about what we know about the truth.
Okay, very good. Could you explain simply what is the top-down approach and why it differs from the current commonly used method? And I think you a little bit covered this during the presentation.
Sure. I mean, top-down is an approach where you first determine an aggregate royalty for all aspects of a standard, for all patent portfolios included in a standard, and then you devise an apportionment strategy to apportion this aggregate royalty to one particular licensor, and that would then be your indication of what would be a friend rate for that particular licensor's royalty rate. So this has been done, not very often, but it has been done, usually in combination with other methods, usually in combination with what is by far the most common method, which is comparable licensing methods. I believe that the striking fundamental conceptual difference between comparable licenses and top-down is basically the posture that the economist adopts. In top-down, it's basically the economist saying, okay, here's what I believe the value is, and based on that, I tell the rest of the world what the price should be. And in comparable licenses, it's a much more traditional role for an economist. So we study a particular market. In this case, it's a market for licenses, and we observe prices in that market. And then we say, okay, based on empirical data, the price in that market is X. And we can then apply that to a particular case. So I think it's a more humble exercise for an economist, but I also believe it's more appropriate than this more normative role where it's the economist postulating what prices should be.
Okay, very good. Let me pick the last question because we receive more. Okay, so the last one is I will have the one that is the broadest one. You conclude that friend determination and reasonable aggregate royalties must be removed from the SEP proposed regulation. If the policymakers follow this advice, do you believe it will increase the chance of success of the proposed regulation, or further fine-tuning will be required?
Yeah, I think it would improve the success. I think that there has been worldwide some experience with regulatory initiatives where the regulator strongly came out on one side or the other of the debate. Usually these proposals have been short-lived and have not survived long, and they have created more confusion than helped. And therefore, I think that this particular aspect of the proposal, which is very far removed from currently observable SEP licensing practices, and it also seems very one-sided to the benefit of one side at the expense of the other. This clearly undermines the success of the regulation in general. If anything else has to be changed, I mean, I think that my personal view is that the Commission's proposal with respect to SEP transparency is philosophically on the right track. I think that overall, I think it's the idea of having a combination of self-registered patents with samples to be checked, not in view of counting patents, but in view of having a register that is more informative than what we currently have. I think that this is the right philosophy. There's certainly tweaks, but I think that these tweaks can be done through implementing regulations after the regulation has been adopted. On the conciliation part, I think there's more work to be done. I think that there's a legitimate concern that this obligation to first consult a conciliator before being able to access court proceedings in the EU would generate a delay, and that this delay would produce or exacerbate holdout incentives. I believe that this would need to be addressed, this concern. But once this concern has been addressed, I believe there's promise in having a conciliation process that courts can choose to rely upon if parties do not agree with the outcome of the conciliation. So I think that if we focus on these other two aspects of the regulation, we improve the specifics of the transparency aspects through implementing regulations, and we address legitimate concerns with respect to the delay that potentially is generated by the conciliation. I think that it's potentially a proposal that might garner support from both sides of the debate, and that could be much more sustainable and also gain international traction in a way that would be beneficial.
Okay, so maybe I could conclude that more time would be required. Clearly, that's not going to be possible in a rush. But now we are very close from the end of this webinar. I would like to thank you very much because you spent 90 minutes. You really provided a lot of information. To the audience, the slides will be made available tomorrow, the recording as well. And for the Q&A, we'll do a transcript, making sure the ones who left will have also access to it. So thank you very much, Justus, for sharing your knowledge, your deep knowledge on this very complex topic. Thank you also for all of you who have participating and waited until the end. Again, I would like to remind you that you should not forget to register for the upcoming webinar that 4IP is organizing on October the 19th at 4, which will be about open source software and friend. Learn more about the governance and compatibility. That will be presented by Dr. Gregor Longus and Dr. Vilen Lipatov. You can find out more using the QR code on the website, as well as under the webinar tab on the website of ipcouncil.eu. Finally, I would like to remind you that you will receive tomorrow a short email asking for your feedback regarding this webinar. Finally, thank you very much again, Justus, for the preparation, the time you spent, and the explanation. Thank you very much and goodbye.